transmission with proceedings continuing on audio-only basis for the proceeding where the violation occurred, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for electronic media coverage of court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter, where the court determines that such a measure is required to ensure compliance with the standing decorum order and to protect the rights of the parties. Counsel will be allowed to provide their input before the court makes any final determination regarding sanctions. I want to emphasize that these measures are not intended to have a chilling effect on open and transparent courts or on responsible news gathering, and the court remains fully committed to the presumption of open proceedings under applicable rules. Rather, they're intended to protect the constitutional rights of all parties while preserving the integrity, openness, and fairness of these proceedings. Third, at this time I wish to address the camera operator. Mr. Uhlberg, if you wouldn't mind coming forward and standing at the lectern. And could you state your name for the record?
John Uhlberg.
Thank you, Mr. Uhlberg. It's not my intention to cause you any embarrassment or discomfort. I simply want to ensure that the guidelines for today's proceedings are clear. Mr. Uhlberg, during today's hearing, what is your primary role?
To provide video coverage of the proceedings for the public.
All right. Have you read the December 23rd, 2025 Standing Decorum Order?
Yes, sir.
Do you understand the guidelines as they relate to your responsibilities today?
I do.
Do you need any additional time to review the December 23rd, 2025 Standing Decorum Order, or any time to reposition the camera to ensure full compliance with those guidelines?
Do I need more time? I'm sorry, was that the question?
Do you need more time to review the decorum order? And I'll pause there because that was a compound question. Sorry about that.
No, I've read it, I fully understand it, I'm good to go.
All right, to the second part, do you need any additional time to reposition the camera to ensure full compliance with those guidelines?
No, I think we're in a good position now.
All right. Mr. Uhlberg, do you anticipate any difficulties complying with the December 23rd, 2025 Standing Decorum Order?
I do not anticipate any problems.
All right. And is there anything that the court can clarify to assist you?
No, I think we're good to go, sir.
All right. Thank you, Mr. Uhlberg.
Thank you.
Before I let you go, I'll turn to counsel based off the questions asked. I turn to you if you have any input or questions.
Nothing from the state.
Thank you.
No, Your Honor.
All right. All right. And the court, I appreciate your cooperation, and it's my hope that we all do our very best today together.
Absolutely. Thank you.
And finally, before we turn to the issue, the motion before the court, to the state, could you please provide a brief update on the status of discovery disclosure?
Yes, Your Honor. I don't have the percentage of materials that we have that have been disclosed, but I think we're above 90% at this point. There still is discovery coming in. There are reports and so forth coming in from various entities. So I think we're moving expeditiously towards completing at least this initial batch of discovery. Of course, discovery will be ongoing probably for the duration of the proceeding, but we have provided nearly all of what we have to date.
All right. And to defense, any input?
Not at this time, Your Honor.
Thank you, Ms. Nestor. All right. Thank you, counsel, for your patience as the court covered those preliminary issues. Let's turn to the defense's motion to disqualify the Utah County Attorney's Office. Ms. Nestor, Mr. Novak.
That's fine, Your Honor. That's okay. We actually have some preliminary things we want to discuss with respect to the posture of this motion. And I also think at some point the court needs to decide at what stage the hearing on this motion remains open and becomes closed. So I'm going to bear that in mind in terms of my preliminary statements, if I may. When we filed this motion to disqualify, and when I say we, I mean Mr. Robinson's counsel, we fully expected that what the Utah County attorneys would do is refer the motion to the Attorney General's office so that the Utah County attorneys are not in the position of representing their own interests as potentially conflicted attorneys in a potentially conflicted office, and representing the state's interest in the prosecution. We heard informally from the state's attorneys that they were preparing a response and when it would be provided. And then what we received, and again, I'm bearing in mind that we're in an open hearing at the moment, was a brief where I'm going to say the unsworn representations of two attorneys from that office are basically integrated into points and authorities. We don't have affidavits from Mr. Gray or from the other attorney. We have argument. We noted in our reply that we were surprised, that's in footnote 2 at page 4, that the Utah County attorneys were representing themselves in connection with a motion alleging that they have a conflict of interest and that the state was not being represented through the Attorney General's office. We did some further research on this, and you know, we have some case law that we can provide the court. I suspect that the court is very familiar with the fact, just from its own experience, that in appropriate circumstances, the Attorney General's office can either, one, represent the state in what was a county prosecution with respect to a disqualification motion so that the boundaries are clear, or if there's an ultimate finding or conclusion that there's a conflict of interest, take over the prosecution or assign it to another county. So we're very concerned that we're getting off on the wrong foot, if I can use that metaphor, because we have officers of the court who are both representing their own interests in continuing to be the prosecutors in this case and representing the state in a situation where there should be what I would call, at least temporarily, conflict counsel. I'm not sure that's the term the Attorney General uses, representing the state's interests. There's a Supreme Court decision which is called State v. Jimenez, Jimenez, which I can provide a citation for. There are subsequent cases, but it's pretty clear that this is the type of a case. I'm not saying that Jimenez compels that action, but it seems to me to strongly suggest that where there is a showing, I'm not sure what the threshold showing is. I don't want to say it's a prima facie showing or a reasonable concern, but where there's a showing that there very well may be a conflict of interest that hasn't been handled by a particular state attorney's, county attorney's office, that what's in the interest of the litigation, of the public, of the parties, is for the Attorney General to step in. And the citation for State v. Jimenez, if I may, is 588 P. 2nd 707. Of course, I can provide the court with the Utah citation as well. This court actually has the authority under that case, State v. Jimenez, to direct the Attorney General to step in, not for the entire case at this stage, that's not what we're saying is necessary, because that requires a finding of a conflict of interest, but to step in or to designate somebody to step in for the purposes of litigating that motion.
Okay.
And so we're very concerned that even going forward with an evidentiary hearing where members of the Utah County Attorney's Office are both litigating as representatives of the state in a prosecution and essentially defending their own propriety of proceeding in this prosecution is problematic. As far as being prepared, we're of course prepared to go forward with an evidentiary hearing, but we think that it's improvident, and we think that what the court should do if the Utah County attorneys have not or don't, if given the opportunity, do this on their own, is that the court should designate the Attorney General's office for the purpose of litigating this motion. The court might ask, hypothetically, the question, has the Utah County Attorney's Office conferred with the Attorney General about this particular question? And we are not in the dark because, as Ms. Nestor will tell the court, as an officer of the court, she's spoken with the Attorney General's office and they have not been consulted about this. Okay? So this is a motion to disqualify a county attorney's office based on what we believe is a material, significant conflict of interest that it's clear they haven't even tried to address by way of a screening, which of course is a term of art, because their position is no screening was necessary. We're not even here to discuss whether the way in which a particular attorney was screened off was adequate. Their position, as their own advocates, is we've already decided no screening is necessary. So what we've been told by the Attorney General's office, Ms. Nestor can represent to the court exactly what she was told, but basically that there has not been consultation. And while that is Mr. Gray's prerogative, we think it's wrong, and we think that this court needs to exercise its authority to intervene and say, in this case, for this kind of a motion, the court needs to hear from a representative of the state who does not even appear to have a conflict of interest. So that's our preliminary statement about these issues. And again, I hope I've avoided saying anything that should have been said in a closed hearing. I think I was pretty good about that. So that's where we are before we even get into the litigation of it. And I don't want to be formalistic, and I'm certainly not trying to be confrontational, but I think actually what we think the court should do is the court should strike the Utah County attorney's response to our motion and direct the Attorney General to take up the responsibility for responding to our motion in whichever way clearly non-conflicted attorneys representing the state think they should, how it should be responded to. And if I've muddled, I always say this, Your Honor, if I've muddled anything or confused anything, please say so and I'll try to clarify.
Thank you. I do have some questions for you as it relates to this. I wish to consider all the authority that you wish to cite to. I mean, obviously you came into this hearing knowing that this is something you're going to present, and this court wants to be efficient with time, but thorough.
Yes.
And not jumping to conclusions. Can you give me all the authority that you wish for me to consider in considering your request today?
Yes, and I think what we could also do, which maybe would be more helpful to the court, is that we could file a short brief on this particular issue, because I will acknowledge that while we were surprised that the brief was filed by the same lawyers who are alleged to have this conflict of interest, it took us a little bit of time to, and we wanted to get that filed in time for today's hearing because the court set the hearing. It took us a little bit of time to think through these issues. So There are Utah authorities. There are authorities from other jurisdictions. There are also ABA guidelines on the prosecutorial function, which we think strongly suggest that there should have been what I'll just call a referral to the Attorney General's office for this particular motion. I can stand here and I can give the court case names and numbers and sections from the ABA standards, but it was not our goal to, of course, put the court on the spot and require the court to, like go back into chambers, think about it for, some pressured period of time and come back out and make a decision. So if it would benefit the court for us to file something, and I don't mean in a month, I mean very soon, so that the court has thoughtfully presented points and authorities, we're happy to do that. As far as I know, the only people who've traveled out of town for this hearing are Mr. Burt and myself. So I'm thinking about the convenience of witnesses and the court and counsel. It's important that we do this in a way where the court has the opportunity to make a thoughtful, reasoned decision, as Your Honor always says. So that would be our proposal, is that if the court is open to receiving authorities, that we recess this hearing for, whatever meets the court's schedule, whether it's a week or 2 weeks or a few days, and we can provide the court with something, and we'll come back. But we do think this is a serious issue, because I think the question of who litigates this issue on behalf of the state is in itself wrapped up in this conflict. And we want everybody to get this right.
Thank you.
Once.
My question for you is, knowing this, why didn't you file a motion prior to today's hearing, knowing that the court would be in this position based off your request to prepare the court, prepare opposing parties, and to be efficient in our use of time? I'm trying to understand. I understand what you're saying, and I understand that things evolve, but I'm trying to understand why that wasn't filed in advance of the hearing to put the court on notice at the very minimum, and just to allow the court to do what the court does.
I hear what the court's saying, and I think we can take responsibility for not sufficiently presenting the authorities that we think compel what I've just suggested should happen. We noted in our reply brief that the county attorneys should not be representing themselves. And that's probably an inadequate message to the court. But we did file a motion to disqualify. And inherent in a motion to disqualify based on the conflict of interest, we anticipated would be that the state attorneys would seek representation from a clearly non-conflicted, appropriate prosecutorial authority, which, as I've done further research, and Mr. Burt and Ms. Visser and Ms. Nestor and I have all done further research literally up until earlier this morning, we think it's pretty clear that this court has the authority to make that, I'm going to call it a referral. I think it's an order referring it to the Attorney General if the Utah County attorneys choose not to do so. And the additional information, which we did receive today, I'll just tell you that, was that there had not been any communication between the county attorneys and the Attorney General's office concerning this issue. So I'll fall on my sword. If the court thinks I should be sanctioned for not bringing this up sooner, I hear the court. But we are we're juggling many aspects of this case all at the same time, some of which the court is aware of, sure. Some of which the court probably is not aware of. But the court can imagine.
No, and I appreciate that. It's not the intent to sanction you. I understand that issues come up, and there's a lot going on. And so the court appreciates your candor and representation today. So these items can evolve. And so the court is not finding fault with you. It's just hoping that as it requires a lot of time and resources for you and for fellow attorneys and for the opposing party and for other parties, we just might want to make sure we make the best use of our time when we're together.
I hear everything the court is saying. I take it to heart. I understand what the court's saying, and we are cognizant of the time that the court devotes to preparation for these hearings. So that's all I can really say.
Sure. And also for Mr. Robinson himself and the victim representative, Ms. Kirk as well. We just want to do our best, and I understand, and I'm not finding fault with you, sir, or your team. We've all been in court. We all know what happened, so I understand. I'll turn to the state. Oh, and I'm sorry. Is there anything further that you wish to represent?
No, like I could provide the court with more citations, but I'm just wondering if that's really the best way to give the court a list of verbal citations. I think with all consideration for, and we probably have, with all consideration for the fact that the court wants to be thorough and careful, and we do as well. We don't want to shoot from the hip, but I think that we just decided that this was something that we needed to bring to the court's attention in a much more fulsome way once we understood not only the way this was developing, but, frankly, the way the Utah Supreme Court, the ABA guidelines, courts of appeals subsequent to State v. Jimenez, and the information that we received today from the Attorney General's office, which isn't a secret. It's just we had a conversation and we learned that there hadn't been any consultation. If there had been consultation and the Attorney General had said, no, we think you're good to go, then that would be different. And that's what we learned this morning.
All right. Well, I'll go ahead and take those authorities right now if you'd like to list them. Court is ready.
So the second one would be State v. Robertson, and that is also a Utah case, 886 P. 2nd 85. There's the ABA prosecution standards. I would refer the court to section 3.1.7 and 3.2.5. And those are, I think, the places to start.
Is there any Utah rule on point that addresses this issue?
So the case of State v. Jimenez, which I referred to, which is the Supreme Court, does actually cite a statute.
Okay. Anything further that you wish for this court to consider at this point in the proceeding as it relates to this issue?
No, and depending upon the statements of counsel, we may have some response if the court permits it.
Of course.
All right.
Thank you. Turning to the state. Mr. Gray.
Your Honor, I'm not sure why this is coming before us today. If it was such a surprise to them more than a week ago, I don't know why they wouldn't at least notify the court. I, too, represent the state. I'm an elected official, constitutionally elected to represent the state. Where does this end? I don't know these cases. I'm very interested to see whether or not they refer to trials. I know that the Utah Attorney General's office, they've done the same thing that we have in Rule 11 motions, where one counsel on the team examines their boss, in fact, on the matter. So I just think this is ambush and another stalling tactic to delay these proceedings. There's no reason that they could not have at least filed the motion and asked for time to brief it. And where does it end? Do we get to respond to their motion to have the Attorney General's office respond, or does the Attorney General's office have to respond to that one too? I'm not, well, anyway, I've stated my, it should have been done far earlier if that was their case, if that was their claim. And if I could just turn the time over to Ryan in case he has something else.
Thank you, Mr. Gray.
Yeah, I
Mr.
do.
McBride.
And excuse me, this is, we're tag teaming this somewhat because it's a surprise to us as it is to the court. But in the 5 minutes I've had to read Robertson and Jimenez, which could have been provided to me before this hearing, it looks like those cases don't stand for conflict of interest cases. They're actually, does the Attorney General's office have authority to prosecute cases that occur within a prosecution district or county attorney's jurisdiction? And the answer is yes. It's not about taking conflicts from the few minutes I've had to read those cases. I do want to state this is, of course, the first time this has been raised to us. The defense has known that we were going to respond to this motion for some time. We requested an extension for our filing deadline back in December. The defense agreed to that extension. Our reply was filed January 5th. The defendant's reply was filed thereafter. And in that reply, the tone of that reply is mentions that they thought that perhaps a special prosecutor would be appointed to handle the conflict case, but in the alternative says we'll be able to, we want to subpoena witnesses to establish the facts that are laid out in the state's opposition motion or memorandum. And that was what we understood was going to happen today. You have a family member of a prosecutor who has been subpoenaed. An affidavit has been supplied to the court. We believe that affidavit is adequate, but it wasn't adequate from the defense perspective, so they subpoenaed that person. Prosecutors have been subpoenaed for today's hearing. We have 2 investigators that have been subpoenaed for today's hearing. And we are ready to go, Your Honor. I think that the motion or the request that the defense has made assumes that a conflict does exist and that there's an inability of the party who has been accused of a conflict to defend themselves. And I just don't think that that's true. If there is a conflict, which is the question that this court is to decide, the case will be referred. Until that conflict has been established, the case is properly in the jurisdiction that has statutory authority over that offense. And until that conflict has been established, the Utah County Attorney's Office has this case and can defend its involvement in this case. If I got just a moment to review my notes and see if there's other points we want to make on this.
Of course.
There is one other point I wanted to make, which is the idea that the case would be referred, that alleging a conflict would cause a special prosecutor to be appointed. That really assumes that there is a conflict, and until that conflict has been established, there is no duty for the case to be referred to another jurisdiction or another special prosecutor to handle. And it raises some of the issues that have been brought up in some of the case law regarding creating or alleging conflicts. There's a lot of case law that talks about how it can be a tactic to try and remove cases from one prosecutor's authority to find a more lenient prosecutor, find a more favorable prosecuting authority that's not going to seek, for example, in this case, the death penalty. And there's a lot of case law that talks about you can't call opposing counsel as a witness in a case unless they're absolutely necessary. And the reason is because it can be a forum shopping effort. And we're concerned with that same kind of motivation or tactic that could be used in this case or other cases like it. Anytime you, as opposing counsel, you don't like the offer you're getting, the way the prosecution is being handled, you allege a conflict of interest, and all of a sudden the county attorney's office has to spend $10,000 to hire a special prosecutor just to handle that one issue, regardless of whether or not it's supported or whether or not a conflict exists. That's a concern we have. Your Honor, we're ready to go forward today. We think the evidence that will be presented today will illuminate the issues adequate that Your Honor can make a decision about whether or not a conflict exists, and we don't need to delay this proceeding any further. We're confident that the court will see the facts as they are and be able to make that determination.
Mr. McBride, so the motion has been made by defense to continue this hearing to allow the filing of a motion addressing more fully this issue. And to that request, what is the state's reply?
We object to that motion to continue or to strike. we ask the court to go forward today. We think the motion is untimely. The court has, or the prosecution has subpoenaed witnesses, and every delay that happens, the witnesses that we have now family members of the prosecution being subpoenaed. These people are ready to move forward and get this out of the way. The longer we delay this, the more anxiety that this procedure has.
All right. Thank you, Mr. McBride. To defense, any response?
Yes, John, thank you. First, I want to say this is not about seeking a lenient prosecutor. This is not about tactics at all. And it was actually the county attorney's office who informed us back in October that there was a family member of a prosecutor who was present at Utah Valley University at the Charlie Kirk rally and experienced and witnessed certain things. We didn't make this up out of whole cloth. We didn't grab onto some piece of discovery and say, a wedge, a tactic. The Utah County Attorney's Office informed us in late October that we needed to know about this, and we informed them, fine, that's your position, it's not a conflict of interest. We think it is, and we intend to litigate it. So it's not a tactic, it's not something that we've made up out of whole cloth because, like I said, we found a needle in a haystack. It's something that they properly brought to our attention, but we firmly believe that the law supports the conclusion that that particular prosecutor should have been screened off. There's good case law on screening, which we did fully cite in our briefs in a timely way, and there was no effort to screen off that prosecutor, and that has now created a problem for the whole office. That is not made up out of whole cloth, and like I said, it's not about tactics or lenience or delay. This isn't delaying anything, at least on our part. The other thing that I want to point out is to say that until this court decides there's a conflict of interest, somebody else shouldn't be handling this issue is circular. Because by that point in time, the court would have already allowed the conflicted attorneys to represent the state in a hearing on their potential conflict. So I actually think the way you avoid that circular argument and the sort of harm that arises if the court were to find that there is a conflict is to at least temporarily have the Attorney General's office handle this. Yes, Mr. Gray is an elected official, but that doesn't mean that his office doesn't have a conflict of interest. Conflict of interests arise. A prosecutor decides to become a judicial officer. That's actually where most of the case law comes from. A prosecutor decides to become a judicial officer. That's actually where most of the case law comes from, as Your Honor knows. A defense attorney changes careers and becomes a prosecutor. There has to be a screening. The case law is very clear that the screening has to be adequate. There's been no screening here because Mr. Gray decided we don't think there's a conflict of interest. And what we're saying is it's not a needle in a haystack. It's not a tactic. It's not a fiction. It's not a thin reed. The evidence that the court has suggests, number one, that there's a very good possibility that as a legal matter there's a conflict of interest. That's why we need to have an evidentiary hearing, because the court doesn't have all the facts. And number two, that the Utah County Attorney's Office, because they decided early on, without consulting with anybody, that they didn't have a conflict of interest, didn't put any screening mechanisms in place. And so I understand that they want to defend the decisions that they've made, but the question is, shouldn't the state be represented by somebody else in the course of this court resolving whether those decisions were right. Because to quote the law and to quote the ethics, the Utah County Attorney's Office is now serving two masters. I don't like that word, but that's the word in the doctrine. They're representing themselves, and they're representing the state of Utah. And that's why the Attorney General or somebody else designated by the Attorney General should be representing them in this matter. And I do want to say one more thing, if I may, Your Honor, and I appreciate the court's patience. I think that the way we raise this issue in our reply brief is not as accommodating to just letting it go as counsel suggests. What we said is we asked the question is whether it is even appropriate for the UCAO to litigate this issue on its own behalf. While the UCAO may have provided this court with the information that it has deemed relevant to this issue, the scope of the disclosures and litigation of this motion should have been assigned to another state agency, such as the Attorney General. We didn't suggest that this court should appoint a special prosecutor for all purposes, or that the filing of this motion means that the Utah County Attorney's Office is automatically disqualified from the litigation. That's the point of the motion, is whether they had a conflict of interest, and if they did, whether they handled it. And it's our position correctly, and it's our position that the answer is yes and no. So I understand there are witnesses here, people are ready to go. We think that the court should either accept briefing or agree with us that the referral is appropriate. And I want to cite, if I may, the citation by the Supreme Court in Jimenez. So this is 588 P. 2nd. It's 707, but this is at 708. This is the statute quoted by the Supreme Court. If at any time after investigation by and a finding and a recommendation from the district judge involved that the county attorney in any county is unable to satisfactorily and adequately perform his duties in prosecuting a criminal case without additional legal assistance, the Attorney General shall provide such assistance. That's very broad. What that means in this case is it's inappropriate for the Utah County Attorney's Office to represent itself when it is also representing the state. And that for this motion, this court has the discretion, we would say, respectfully the obligation, to designate the Attorney General to represent the state, the people of the state of Utah, in this motion. And depending upon how the court rules on the motion, then we have to see what happens next.
So is it your position that the court has discretion to make that decision?
I think that the court has the discretion to say to the Utah County attorneys, you shouldn't be representing yourself in this case at this stage as to this motion only. Continue to do what you do while this motion is pending, and we will resolve this motion. I am not suggesting that they should stop the work that Mr. McBride talked about preparing discovery, having their agents interview witnesses. We want to get this motion resolved in a timely way. It is not a stalling tactic. But I'm not saying, let me be very careful because I don't want to misinterpret the court's question. I'm not saying that whatever this court decides is the right decision because the court has discretion. We believe that the law requires that the county attorney's office be represented by somebody else for this motion. What I'm saying is the legislature gave the court the authority to compel that when the state attorney and the attorney general haven't done anything about that yet. I'm not saying that the court, I don't know what the standard of review on appeal would be, so I'm not just saying it's an abuse of discretion standard. What I'm saying is the legislature gave this court the authority to direct, refer, to the Attorney General representation in a criminal case where there's a showing of a potential conflict of interest. And I've been a criminal litigator, although on this side for a long time, so I understand what counsel's talking about is sometimes defendants come up with questionable grounds and move to disqualify. And I don't think that that's a finding that the court can make in this case. It was actually, as I said before, the Utah County attorneys who were concerned about this enough that they brought it to our attention. We have profound disagreements about the significance of the conflict and the way it was handled. Okay?
Right.
And otherwise, I think I would be repeating myself if I said anything more without answering a direct question.
All right. I just have a brief question. Do you have your witnesses here today?
All the witnesses are here. We have no problem as a pragmatic issue going forward. Our witnesses are the subpoenas that we served, which were filed with the court.
Okay.
So to be clear, I don't think the court is inferring this. We're not unable to proceed if that was the court's conclusion. We are prepared, and the witnesses are here. I'm just saying we think that it would be improvident and it could result in errors of law, and it could result in problems down the road.
Thank you. Do you need any additional time in regards to your argument to continue this hearing based off the citations you've provided, the authorities you've provided the court?
1 second. No, thank you.
All right, thank you. What this court intends to do is, this is an important issue, and I realize the totality of what's been presented. And my question in regards to your witnesses is, it was informatory. I just wanted to see if depending on what the court rules, if the parties, I don't want to disadvantage either party in that. So this is an important issue, and this court wishes to take a brief recess. I want to look at what's been provided and make see where the court needs to go. I want to inform myself, take a moment to look at it, and as opposed to just making a snap decision and taking into consideration all parties and the constitutional rights of all parties as well. With that, we will be in a brief recess. I always hesitate to give a time because
We'll be
sometimes
here.
I appreciate you being here. Court is in a brief recess. Thank you.
All right.
attending Turning Point at UVU on the day Charlie Kirk was shot and killed. The family member texted the prosecutor almost contemporaneously. We'll pretend I said that word right. With the event, and shared that they had heard the gunshot and that they had run with the crowd, and other observations, feelings, and reactions. Thereafter, the prosecutor went to UVU and investigated how far away his family member was to the shooting. The family member had left a backpack when they fled. Prosecutor determined that the family member was approximately 85 feet away from Charlie Kirk when he was shot. In my view, those are the alleged facts that the court must consider to answer the first question. Does a prosecutor, by virtue of his relationship with a family member who witnessed the shooting, have a conflict of interest under Rule 1.7? And in turning to that, just looking at my notes, I appreciate your patience. And so turning to defense, if I accept the facts as you have alleged in your motion as true, is there any reason to call witnesses to answer the first question before the court? And before you answer that, I understand that there are other relevant facts that pertain to the effect of the alleged conflict. Those facts would include whether the prosecutor was properly screened from the case, what conversations he had with other prosecutors, and whether the family member's experience impacted the state's decision to seek the death penalty. It is the defense position, as I understand it, that those facts may need to be explored through witness testimony. But if we're just talking about the first question, whether the prosecutor has a conflict of interest under Rule 1.7, is there a need to call witnesses?
Yes, Your Honor. I understand that the court is trying to get to the threshold question that we have put before it with respect to who should be representing the Utah County Attorney's Office in this motion. But the answer to the court's question is yes, because it's not just the mere transactional event that this that the offspring witnessed the shooting. It is the evidentiary development will get at, and again, we were only provided with an affidavit, which was very, if I may, narrowly drawn, at communications that happened after that between that offspring and their parent, between that offspring and other family members that may have been communicated to the parent, communications between the parent and other people in the office, the impact. Okay, so now I'm going to just say, if I had found out that my child was at an incident where somebody was shot and killed, I would have an incredibly strong emotional reaction, even if they were safe. Okay, so give me a second, okay? There was a horrible shooting incident at Brown University a few weeks ago. And I have a child who lives within 20 miles of there who was in Providence that day. And everybody in our family was really freaked out until we knew that they were safe. And then even when we knew they were safe, the question was, what did you see? Did it affect you? Turned out everybody's fine. But it's not just, oh, I was there. Right? And my family member didn't witness a shooting. Wasn't in a crowd with 3,000 people who all had to run and take cover in case there were more shots fired, in case there were some other harm that occurred. Okay? So it's not just the fact that this person was 85 feet away from Mr. Kirk. It's that begins to that scratches the surface, if I may, of the totality of the circumstances, which we think created a conflict of interest. So the answer is yes, and that's why both the parent and the offspring are here. and are under subpoena and agreed to be here and agreed to testify. Obviously, it's the court's proceeding, but nobody's moved to quash, and I think it's obvious that that's because we need further factual development. And our reply brief, if it did anything, it communicated to the court the case law which shows that this is a fact-intensive inquiry and that affidavits are required. And here we don't have affidavits from the parent or from Mr. Gray. We have argument in a brief. But we also believe that testimony from the offspring is necessary, and they're here, and they agreed to be here. And they agreed that Ms. Visser could sign an acknowledgement of service of a subpoena. So the very, very long answer to the court's question is yes, definitely. We need to have an evidentiary hearing.
But isn't defense required to make the threshold showing from the facts that you're asserting? Isn't that where we begin? Not necessarily the state's response, but don't you have a responsibility to show that you've made a threshold showing of what you're asserting would rise to what you're asserting in your motion?
So the state, so the Utah County attorneys informed us that this offspring was present in a crowd, was caught up in the ensuing chaos, heard a shot fired, had to leave their belongings behind, witnessed the trauma of other people. We can't really get beyond that without fact development. I mean, if what the court is saying, hypothetically, is I want you to go sit down and interview people, that's one thing. But if the court's saying that we somehow should have more information than the county has given us, we can't do that without evidentiary development. Okay? We have questions about whether there were more non-recorded communications that we haven't been told about. I think we have a good faith, and the court could imagine that a family would talk about such an incident, and it wouldn't just be the text messages that the court has in the exhibit. And I don't purport to say anybody should run their family the way my family operates. I'm just talking about what I think would be natural, which is families talk about these things because we want to take care of our kids, and we want to make sure they're okay. And then we need to make sure that our responsibilities to the public and to justice aren't impacted by our personal experiences. And I think that we can only get at that, Your Honor, through evidentiary development.
All right.
And that's why, and I think that the state would agree with that, because that's why they provided the court with some affidavits and some fact in the course of argument. So I think that it needs to be fully developed through the very limited number of witnesses that are present.
I understand. Let me turn to the state. What's the state's position?
So I want to make sure I'm understanding your question. The question is, there's two layers here, right? The first layer is, when an alleged conflict arises, does in this case, the county attorney's office have to conflict the handling of that allegation to another special prosecutor, attorney general's office, right? Your question is, doesn't the defense have to make an initial showing before that first conflict has or occurs that requires that delegation?
Yes.
Okay. My answer is yes. I mean, otherwise we have to have a hearing to determine if another entity has to handle the substantive issue. And then you have to have another hearing to determine if there actually is a conflict. I think there has to be at first a showing that there is a basis for a conflict. Otherwise, someone can come in and say, I think there's a conflict without any evidence whatsoever, or not evidence that's credible. I think, and for that reason, I think the court should be able to make this threshold showing based on the affidavit, right? The affidavit and the facts that have been proffered. I think there's enough there for you to say, yes, the county attorney's office can handle this motion on its own, or no, this motion needs to go to the Attorney General's office, whoever else, to handle the substantive issue of whether or not there's a conflict. I mean, I want to be clear. I don't believe under any of those circumstances that the issue needs to be conflicted out. I believe that until a conflict has been found, the county attorney's office or whatever entity has been accused of a conflict can litigate that issue without litigating that issue.
All right. In regards,
Did I make myself clear?
I appreciate that, Mr. McBride. A follow-up question in regards, they're proposing calling witnesses to make that threshold showing. What is the state's position?
No, I mean, my position is no. I think witnesses should be called one time in this case, and that should be to determine whether or not there's a conflict, not to determine whether or not the issue of whether or not there's a conflict should be conflicted.
Okay. I think there may have been a little bit of confusion there, and I'll take responsibility for the question. In regards to the threshold showing about the conflict, so the threshold showing of a conflict of interest under Rule 1.7. So the AG's it seems to follow after in time to see if there's a conflict initially. So in regards to establishing that, defense, and I don't wish to speak for you, but my understanding is you wish to call witnesses to put that evidence on.
Then I misunderstood the court's question. I don't think we need to take testimony in order for this court to make a finding on under 1.7 that conflict-free counsel should represent the state in this motion. I am not suggesting, and I didn't mean to, that there should be 2 hearings. That's not what, so if I misunderstood the court's question, I thought the court was saying, do we even need an evidentiary hearing on your motion to disqualify? Isn't it enough for the court to just read the papers? But that was not, was that your question?
Well, and I'll take full responsibility on my question. That was really the push on it, because my understanding is that determination needs to be made based off what you told us in the beginning, that a showing of a conflict of interest, there has to be a very good possibility of a conflict, or showing of a conflict is the very first step before we go down the further road of addressing the AG's office. And so I was alluding to, based off that, does that require an evidentiary hearing from your perspective?
I don't think that it requires an evidentiary hearing, but I don't want to predict or make assumptions about the court's view. I believe that the Utah County Attorney's disclosure to us on October 20th of this situation and our assessment that it creates a conflict of interest is not frivolous. It's not taken for the purposes of delay or tactics. It's a real potential conflict. I don't know what the threshold showing is that permits or requires the court to exercise its authority under what is now in juxtaposition to the Utah legislature changes its code so often, like we have to figure out all the new code numbers, but it's now section 17-68-304, which gives the court the authority to appoint the Attorney General in this situation for this purpose, 17-68-304, as opposed to the code section cited in Jimenez. The law is the same, but the code sections have changed. But what I'm saying is, I don't want to predict or gamble with what showing this court thinks is necessary in order to appropriately exercise its discretion to make that referral. And so if the court says I need more, then we should have an evidentiary hearing, because the important thing is to get it right, not for me to bargain on whether our papers show enough. The only thing that we know that we can show in our papers is what we were told and what we were given. And we were given some text messaging between family members and maybe some other people. I mean, the court has that, it's an exhibit. That's all we really have. And so I don't want to just say, oh yeah, there's enough there, and then have the court say, no, there isn't. Because it may be that the court wants to take some permit us to take some preliminary testimony in order to make that decision. But what I really think, instead of starting an evidentiary hearing on a motion to determine if there should be a referral, I think that there's a sufficient showing that there should be a referral by this court because of 1.7, under the court's authority under Utah Code Section 1768-304, before we even begin to take testimony. I mean, the fact that Mr. Gray is going to be the first witness we call already, and that the state hasn't moved to quash because it's a frivolous subpoena, or it doesn't have, there's no basis in the factual predicate to examine Mr. Gray about these things, suggests that there's a problem here, that Mr. Gray's office is representing Mr. Gray while also trying to represent the state. And that's an inherent problem. And I understand it's a thorny question. It's what's the showing that's necessary, and does the court have discretion, or is the court compelled to? Is the court going to commit error if it doesn't? That's why I think that maybe some thoughtful briefing is an appropriate thing to do. Before we start an evidentiary hearing and then realize that we got off on the wrong foot, because there should be somebody else seated at counsel table when two members of the state's attorney's office, who are members of the prosecution team, are two of the 4 or 5 witnesses in this hearing.
All right.
So I'm not trying to dance around the court's question. What I'm really saying is, I don't know that we can be stuck with only being able to give a court a showing based on the evidence we've been given, when all we've been given is a memo that says, this person was there, we don't think it's a problem, they were 85 feet away when Mr. Kirk was killed.
And so, and I appreciate what you're saying, counsel, but what I'm trying to determine is, in your regard, in your understanding, I want to address this, the sufficiency of the showing. Is it your request for an evidentiary hearing for you to present to the court enough evidence for the court to make that determination, or something else?
If the court doesn't believe that the papers themselves sufficiently demonstrate that for purposes of the motion to disqualify, the state should be represented by somebody else, then the answer is yes, we want to have an evidentiary hearing up until the point where the court reaches that conclusion. Because that would be the only way for us to satisfy whatever showing the court deems necessary. So I'm not going to waive an evidentiary hearing if the court's saying, well, I don't think you have enough evidence here. Obviously, the answer is yes. What I'm really just saying is, I think that based on the papers, the court can say, yeah, this is a significant problem in a serious case that has really, really serious consequences for Mr. Robinson, for the people of the state of Utah, for the victim's family, and we should do this carefully and correctly. And I think the way to do that is to have the Attorney General of Utah designate somebody in their office to represent the county for this limited purpose until the court determines the scope of the conflict. We think the conflict requires disqualification from the case, but ultimately, obviously, that's going to be a judicial determination.
All right. Anything further from the state before the court makes its ruling on this issue?
I just want to clarify, you're talking about the need for an evidentiary hearing in order to determine whether or not the county attorney's office can handle the motion to disqualify?
No, I'm determining just an initial showing of a conflict that exists here. Like
Well, for what purpose? To disqualify the office or to have the Attorney General's office step in and handle the disqualification motion?
To disqualify the office.
Can I take a crack at it?
If you wouldn't mind, Mr. Gray, just stepping to the lectern, just so the record picks you up. Sometimes these microphones are a little long.
If I could take a crack at it. Basically, I think what you're saying is kind of like a Frank's hearing where you have to allege sufficient facts so that based on those facts, if the court takes that as true, then you would need whether or not there would be a legal basis to conflict it out or find a conflict, right? And so if they don't make that showing, then the court can rule straightway. But if they do make that showing, if what's alleged is true, then we go to an evidentiary hearing. Is that?
Mostly, it's the initial showing of a conflict. And what happens after that will be determined because they're bringing this up for the first time today.
Basically like a prima facie showing initially, is that what you're saying?
Essentially.
Yeah. Okay. I think that's, I'll let you.
No, I appreciate your clarification. Mr. McBride.
Nothing else.
All right. It's the court's, and I've read the briefing by all parties and listened to the argument today, and I don't believe a sufficient showing has been made for the court just relying upon the briefing itself. And so I can't make that finding based off, well, I would find that that threshold showing hasn't been met based off the briefing. And turning to Mr. Novak, based off that finding of the court, what is your position?
Our view is that if the court has concluded that the briefing does not yet rise to the level of proof that the court should at this time make a referral, then the court should begin to take evidence. And there may be a moment where the court says, okay, I've heard enough. Now I'm ready to make a referral. And we're going to stop and pause and wait for the Attorney General to engage. And then we'll have to see where that goes. But it may be that we have to finish the evidentiary hearing. But, and I think all of us can attempt to prioritize the portions of our examination so that the court can make that finding as early as possible. I'm just trying to avoid doing the hearing twice.
I understand.
Because right now, it's our view, the state is not being represented by the attorneys who should be representing it. And so if the state's going to come in later and say, well, we want to redo the evidentiary hearing because the state wasn't represented by the right parties, I mean, it's just, or by the right lawyers, that's something that we would want to avoid. We want to do this once out of a courtesy to the court and to a couple of the witnesses.
No, I appreciate that. And can this be accomplished by proffer?
I don't know what the witnesses are going to say because they've only given us very limited information. The state elected to give us information in their briefing, some of which is, like I said a few times now, is not sworn by affidavit or declaration. It's in the nature of argument. I mean, there are portions of Mr. Gray's brief, he signed it, where he makes many, many assertions of fact in the course of arguing the legal issues. And none of that is sworn. And I mean, I'm sure that, and I think, so I don't think that there can be a proffer because I don't know what the proffer is. I know that I have a lot of questions about things that that the court was not told about in the briefing and the affidavits. So the answer, respectfully, is no, it can't be done by proffer.
All right. And which witnesses are you intending to call today? And I understand you're saying you wish to just put on enough and focus on the key issues, but just if I were to grant, I'm just trying to understand the scope.
Well, I think Mr. Gray is the first witness. The second witness.
We may approach.
Yes. Parties to the bench, please.
Okay.
Thank you, counsel. In regards to the question of what witnesses do you anticipate calling?
Mr. Gray, I'm going to get his title wrong, but Mr. Christensen is an investigator with the county attorney's office. The prosecutor, who we believe is conflicted off, and their offspring.
Okay. All right. Any input from the state at this point? All right. I'm assuming the next portion that we need to address is your motion in regards to the hearing itself, the evidentiary hearing, whether it's closed or open. Correct?
Is the court looking over my shoulder at
No, I'm
media
looking
counsel?
at no, at you.
Okay.
Sorry, there is someone behind you, but I was trying to look at you. That monitor's in the way, but I appreciate the clarification.
When the county attorneys informed us of this factual issue, and we told them that we thought that there was a disqualifying conflict, we had an agreement that we would file our motion privately, I think is the correct term,
Sure.
so that certain identities were protected. And that was at the request, and we've continued to accommodate that, and we have no problem with that. So we are not pushing for this hearing to be closed, but we totally understand why it's appropriate to do so. And it is, and Mr. McBride has verbalized this very well in conversations among counsel, the record is going to be very, very muddy if we can't have examinations that use names and identities. It's just going to be super, super awkward. And so that's why we are fine with the hearing being closed, which I think it's fair to say we view as an appropriate deference to the requests of the county attorneys.
All right. To the state.
Given the extreme publicity and the issues that surround this case, we would ask that this portion of the hearing be closed. We've had communications with counsel for the media. We believe that they agree to that after taking a balancing test of the public's right to know and the right to an open proceeding and the privacy interests at issue.
All right. One of my concerns that I have, and is there any other parties weighing in?
I think there may be, Your Honor, both by
Your Honor.
Vertex and here in person.
All right. Well,
Your Honor, this is Jeff Hunt. Can you hear me?
I sure can, Mr. Hunt. Thank you.
Your Honor, thank you for the accommodation and courtesy to allow us to appear remotely. With me is my colleague, David Ryman. We represent the Deseret News, KSL, KUTV, and other news media. We would like to speak briefly to the closure issue, if that's okay.
All right. I'll hear from you.
We did meet and confer with counsel for the state and counsel for the defendant concerning closure. And counsel has explained that they believe it would be impossible to conduct this hearing or even portions of it in open court without causing prejudice to the privacy and personal safety interests of the family member witness involved. They've told us they believe it would not be feasible or practicable to approach this on a witness-by-witness basis or an issue-by-issue basis because they believe the names of the prosecutor and the family member would be used throughout the examination of witnesses. So we have no reason to doubt the statements and representations of counsel, and in reliance on those would not be objecting to closure of the evidentiary hearing on the disqualification and the referral issues unless the court has a different view and believes that we could parse this on a witness-by-witness or an issue-by-issue basis. That said, Your Honor, we understand that counsel for the state and the defendant have agreed to review a transcript of any evidentiary hearing and make limited and appropriate redactions so that a public version of the transcript could be released. And with that, there are just a couple other brief points I'd like to make. First, we think that this should be the rare exception to conducting these proceedings in open court. There's a strong constitutional presumption of open and public court proceedings, and of course, enormous public interest in this particular case. That openness and transparency is an institutional value that serves this court, the participants, and the public well. The facts and circumstances of this particular motion, given the fact that it concerns a family relationship of the prosecutor, makes it a very extraordinary and unique situation that we feel, given the representations made, can justify the closure. Although we do believe in most cases just the fact that a motion implicates a witness will not be grounds for closure. Second, we just wanted to get on the record that we believe that release of a transcript is not an adequate substitute for the ability of the public and the press to attend and view the proceedings themselves. For this particular evidentiary hearing, that may be the only practical mechanism for the public to obtain some information about the case. But again, we would expect this would be the exception and not become a regular practice. And finally, Your Honor, it's our position that any oral argument on the disqualification motion or the referral motion should be conducted in a public hearing. As this hearing itself has shown, a lot can be done and argued without disclosing the names of family members or the witness at issue and jeopardizing those interests. Counsel can refrain from identifying the prosecutor or family member to protect the asserted privacy interests. And we have experienced counsel. They could be mindful of that issue during oral argument, and it's not unduly burdensome for them to take those steps, and any burden would be greatly outweighed by the public interest in learning more about the motion and having at least an open argument. So we do believe that the argument, and I understand the argument will be made at a later date, not today, but that should be done in open court. That's all I have, Your Honor.
Thank you, Mr. Hunt. Anything further from the parties?
Your Honor, as to the oral argument, it is our request that it be closed, and the reason why is that we're not perfect. Names slip. It's happened in trials. It's happened in arguments before, and I'm concerned at the risk that could have if one of the parties, one of the attorneys, were to slip and identify those who ought to be protected. With that said, a fallback position could be not live streaming the event and requiring any redaction should an inadvertent mention of a name be made.
Thank you. Counsel, one of my biggest concerns is I have to make findings of fact that are very specific. I can't redact my findings when I issue an order. And I will have to cite to the relevant facts. And quite honestly, the name of the prosecutor is a relevant fact. I can't simply glaze over that and make an assertion. It's important because it relates to various factors that you may address, and which has been brought up in briefing. And so this court is going to deny the request to close the hearing as it relates to, and I will take this motion witness by witness. I understand that there may be a witness that this is applicable to, and the court will entertain that, but because this court has to make findings and has to cite to the facts, I need to be able to do that. And since I'm going to do that anyway, which I will, I'd rather address it in an open court. And again, I will entertain any motions, witness by witness, that are going to be called, and be respectful of that. But going to Mr. McBride's point, you both have that duty. It's in regards to how you present, and if you're talking about a name that needs to be protected, that's on you, on how you speak. I can't. It seems inappropriate to create a safeguard to prevent you from making a mistake on accidentally saying a name. That I don't believe that would be a proper reason to close the hearing just for that. And I understand the pressure, counsel. I know it's difficult, but I cannot accept that as a reason to close the entire proceedings for the evidentiary hearing portion. But again, as the witnesses are called, I will entertain the motion whether to close the hearing per witness, and we will address it as we go. Mr. Novak.
Yes, sir.
Yes, Your Honor.
With that, how would we like to proceed? Well, first, is there any clarification needed on this court's ruling as we're proceeding into the evidentiary hearing?
I just want to clarify. Are you going to entertain motions to close at the outset of every witness? Is that what I understand?
If the motion is made, yes.
Okay, thank you.
May we have a moment?
Yes. Oh, looks like I'm off. Would it be easier just to go into a brief recess? I don't want to make you feel rushed. You have obviously important conversations. So it's the court's intent to enter a brief recess to allow the parties sufficient time to discuss whatever you need to discuss.
No, I think I'm comfortable moving forward, making a proffer right now, and asking you to reconsider that motion. And the reason is because courts, the Supreme Court of Utah, appellate courts, refer to witnesses by their initials all the time. In our pleadings, we often refer to witnesses by their initials. In Supreme Court of the United States opinions, witnesses are referred to by their initials, and that's because there's a privacy interest. In this case, I don't think a privacy interest could be greater. This case has polarized the nation in many ways, and there have been death threats made against other witnesses. There have been death threats made. My understanding is there's been threats against counsel. Our office has received threats. Doxing is a real thing. Finding people online, harassing them online. With the technology that we have now, it's not that hard to find out just about every detail about a person through internet searches, paid subscriptions to programs that do background checks. And we are extremely concerned that we will have a person that does not need to be subject to death threats, to harassment, to doxing, to all of those things that can be avoided. We're very concerned that that will happen, and happen to this person for no other reason than this person's father is a prosecutor on the case. Your Honor, I think that there's a way around this, that we can avoid those threats to her, those risks to her, and I think it's by referring to substitute names like we have in the public pleading. So, Your Honor, I would just really ask you to please reconsider your opinion. There's a stipulation from the media to shut this portion of the hearing. There's stipulation from the defense. I think the court in its ruling can refer to the prosecutor as the prosecutor. I think it can refer to the child as adult child. I think that would be adequate. I think in a sealed record, there can be references to names. That would be my request, Your Honor. I can't ask more adamantly than I am now, Your Honor.
To defense.
We take no issue with anything that counsel has said. That's why we completely deferred to the the county attorney's initial request that all of the briefing, as much as possible, be under seal and then redacted.
Thank you. One of the points that when I was considering this as a potential issue is that both parties filed a public version of your motions, and you used a mechanism to convey that same information. And I understand that that makes it tricky, but it was the choice of the parties to do that, to publish those public versions. And the court is fine in regards to particular witnesses referring to those terms that were used in the motions, but this court does not agree that the entirety of the evidentiary hearing needs to be closed. And it is a very broad approach to a narrow issue. And I understand and I respect the concerns made by Mr. McBride, and I understand that. And the court is willing to go witness by witness. If you feel that a particular witness, that needs to be closed, the court will entertain that. I understand the issues of safety, and the court feels the urgency and the importance of that has been stated. But this court cannot find that the closure of the entirety of the evidentiary hearing is proper, given the motions that have been filed publicly online. And I have to leave it to counsel in deciding how you present the evidence, how you state the names. I'm willing to abide by the format used in those public motions, but this court denies the request to close the evidentiary hearing. And again, we'll take witness by witness a motion if that particular witness needs closure that particular witness's examination needs to be closed.
If the court's ready to begin the evidentiary hearing, we would call Jeffrey S. Gray as the first witness.
All right.
Or if the court wants to take a little break, we can do that too.
The courts can move forward. If parties need a break, I'm happy to give a break. I know we're switching gears here. Yeah, go ahead. In fact, let's go ahead and take a brief break. We need to relocate our court reporter, so this is a natural spot to take a break.
Can we have 1 moment of sidebar?
Absolutely. Hold on, counsel. All right, court is back in session. Counsel?
I believe the exclusionary rule is being invoked.
Yes, Your Honor, we'd ask the court to exclude all witnesses during the testimony of other witnesses.
All right, and to the state, any input?
We agree.
Okay. And at this time, would it be convenient to just take a brief recess?
Yes, please.
All right, it's 3:20. How about we come back at 3:30 and resume on the record?
Sounds good.
All right, court is in recess. to articulate what this first clip shows?
You know, I think the clip shows that the camera is zooming in the first clip on Mr. Robinson's lips as he is trying to communicate with me sitting next to him.
Thank you.
If I may reapproach with the second video, Your Honor.
Yes.
This one is 5 seconds, Your Honor.
It looks like, okay.
And Your Honor, the second video is a clip from a court TV posting showing Mr. Robinson's lips moving as he's attempting to speak to Ms. Nestler. And Your Honor, one last thing I'd like to add, if I could, which is I think the court very correctly and very cautiously admonished the cameraman about your December 23rd order before this hearing began. And he said he understood the order, and I think the order is very clear as to this lip reader provision. And I can elaborate further why it's damaging, but I think it's obvious to the court if the media is allowed to interpret the conversations between counsel and his lawyer, it creates all sorts of problems in terms of Mr. Robinson's right to a fair trial.
Thank you, Mr. Burt.
Thank you.
And just one more question. I apologize. Just for the benefit of the record, from your position, citing to the standing decorum order, the violation itself, so we can connect it all from your arguments.
Yes, Your Honor. I forget the paragraph, but there is a paragraph in the court's latest December 23rd decorum order.
It's
I think
paragraph 48.
48. And it's been a feature of every decorum order. I think we're on the third one. But from the start, the court has prohibited zoom-ins to allow lip readers to interpret what's being said between counsel and the defendant.
And finally, I think you led with this in regards to the sanctions being requested. You cited to the court sanctions, and then there was a second one referring to, and I want to make sure I wrote it down right, because
Sure.
Something along the lines of not showing Mr. Robinson at all. I want to make sure I understood that request.
Sure. The request was either to exclude the cameras for purposes of this hearing in its entirety because of the violation and because we can't be assured that the cameraman's going to comply with the court's order. The second request is if the court is not going to exclude the cameras, then it should, at the very least, order the cameraman not to shoot any footage of Mr. Robinson, that the camera should be focused on the court and the witnesses if the court permits that, but it should not be zooming in on Mr. Robinson. His demeanor, his conversations with his lawyers have nothing to do with the newsworthiness of this case. And what it's allowing is very prejudicial information to be leaked to the public through these lip readers and body language interpreters, and it's creating massive prejudicial publicity for us. So that's the request.
Thank you, Mr. Burt.
Thank you.
I'll hear from other parties if they wish to be heard.
Yes, Your Honor. Michael Judd on behalf of the media entities. I want to take the court back to that specific paragraph of the decorum order because I do want to make sure we're on the same page about this. It's the second sentence of paragraph 48 of the decorum order that I understand is at issue here. It does say no visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel, at counsel tables, or bench conferences with the judge. The zoom-in language that you have heard referred to previously doesn't fall in that sentence. The zoom-in language comes in the next sentence, which says no one may zoom in on anything on counsel's table or the bench to identify any writings. So those are two separate things. The first that we learned about this was during the break. I briefly reviewed the two videos that the court has reviewed. I understand that those were 9 seconds and 5 seconds long. I identified the provision of the decorum order that I believe applied here, spoke to the pool cameraman about that, ensured that the rule about capturing conversations involving counsel at counsel's table or at the bench so that they may be decipherable by lip readers was an important provision in the court's decorum order, that it should be followed. I understand that the cameraman understands that rule, that any capture of those conversations was inadvertent. I understand the concerns raised by defense in this case about potential prejudicial effect of something that is intended to capture conversations. I don't believe that that's what occurred in this case. I believe that the court's order should be understood and applied as written and done so strictly. But I don't believe that there's been a violation here. We've been now on the record for 3 hours. I believe that the total length of the two videos that were shown to the court were 14 seconds long. Whether or not either of those conversations rises to the level of capturing the movement of somebody's lips so that it can be decipherable from a lip reader, I'm not in a position to judge. But I can assure the court that the media is aware of that provision, of defense's concern about the potential violation of that order, and that they will take that seriously. That's already been raised, already been discussed. As far as the remedy sought here, I think that excluding all cameras from the courtroom for this important part of this important proceeding would be broader than any sort of remedy would be necessary here, as would the direction that the cameras not show Mr. Robinson in any way. I understand that potentially any shot on a still camera, on a video camera, of a defendant in a criminal case could potentially be twisted or used by some to try to impute some sort of thought or some sort of idea. But I don't believe there's anything in the court's rules. I don't believe there's anything in the ruling so far to date that suggests that the way to address that kind of concern is to say that a defendant, a critical figure in a case like this, and one that the decorum order clearly allows to be photographed and videoed, be kept off camera altogether. The media continues to take this seriously. Before every single hearing, we speak about the decorum order and what it requires. We recognize the importance of doing it and that there can be consequences if that's not kept. The media understands and hears that and do not believe that any further reprimand or any sort of further exclusion is necessary here.
Thank you. But before I turn to you, I want to turn to the stage. I want to give all parties an opportunity, and then that allows you to respond to whatever they say.
Your Honor, we have nothing to add. We'll submit the issue.
All right, Mr. Burt.
Judge, the problem with that explanation, that's the same thing they said last time on December 11th. And on December 11th, there was a same violation. Lip reader. I can pull up for the court what the electronic media did with the prior violation. They hired a lip reader. The lip reader purported to derive a confession from the incident, and they posted that. It's still up there. So it's great that they apologize, but once this kind of damage is done, it is irreparable. And we can't continuously have violations where the media gets up and does this mea culpa, and they just continue to do the same thing. And I point out to the court, this is the same pattern that happened in the Korberger case that's discussed in the motion we filed today. And eventually the court there had to order that all coverage of Mr. Korberger's face was prohibited. And we attached that order to the motion that was just filed with the court. And I understand the media's desire for dramatic coverage. I understand how they want to incriminate Mr. Robinson. But that process is supposed to happen in a trial, not in the media. And it's a serious violation. It's one that the court should not just blink away and say, I accept the apology, especially after the court was so clear this morning. Calling the cameraman up, asking if he had read the December 23rd order, and his response was, I'm good to go. Meaning he had read it, and presumably he read that provision about zooming in on lips. There's no excuse for it. The court should take some action.
Thank you, Mr.
Thank
Burke.
you.
Anything further from any of the parties before this court makes a ruling on this issue that's before it?
No.
I just want to make one note, Your Honor. Those clips that I showed you are just small portions of much longer footage that was available in the live stream. That was just what we needed to compartmentalize to get it to Your Honor, but it was a much more extensive period of time.
All right. All right, I appreciate this being brought promptly to the court's attention. This is an important issue, and the court takes it very seriously. As it relates to today, well, first, I did put on the record very clearly that there would be potential consequences for any violation of the court's December 23rd, 2025 standing decorum order. For the first part, well, and I've also had a chance to view the two clips that was presented. It was shown to all parties. The first appeared to show an attorney and Mr. Robinson speaking for about 9 seconds is what my memory tells me, reminds me. The second clip was for about 5 seconds. I believe it was from a slightly different angle, but it also captured that. And in both instances, I could see Mr. Robinson's lips moving, and I don't remember about the second clip, but I believe in the first clip it also showed counsel's lips moving, but notwithstanding, that was in place. I also refer to the statement made by the counsel for the news media, and going to it is paragraph 48, and I will read it in its entirety. No audio recording is permitted of the conference involving counsel at counsel's tables or during bench conferences with the judge. No visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel at counsel's table or bench conferences with the judge. No one may zoom in on anything on counsel's tables or the bench to identify any writings. Now, in regards to the zooming, I know there was a representation, and it's easy to, as you're reading, to kind of combine it, but I'm not finding that zooming in relates to the lip reader portion, but that's not material. I do find that, and I'm not a lip reader, so I don't know what the standard is for lip reading, but I do note that 9 seconds in that first clip, one could see his lips moving, and it is a significant time as it relates to this particular issue. It wasn't a passing shot. It was focused on these two persons, and so I find that the decorum order, as it relates to paragraph 48, as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader, I find that has been violated. In regards to the second clip, 5 seconds, where it shows Mr. Robinson and I believe one of counsel, that I was able to view Mr. Robinson's lips moving. It wasn't a passing shot that it just so happened to capture. It was focused on them. I find that is a violation of paragraph 48 as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader. Turning to the next section, finding that the violations have been shown as the court has reviewed the purported evidence of these two violations, I turn to the sanctions. Previously, I stated that under Utah Code Section 78B-6-310, if the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both. I find that applying this sanction would be disproportionate to what the conduct was in those two clips. And the court notes that it is the court's discretion on whether to apply it or not. I find that the court will not issue this sanction. In addition, the other sanctions, the court stated earlier today, in addition, the court may impose the following remedial measures if warranted. immediate suspension of video transmission of the hearing, with proceedings continue only on an audio-only basis for this proceeding where the violation occurred, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for the electronic media coverage of the court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter where the court determines such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. The court also stated that before making a decision, it would allow counsel to make argument or statements, in which the court has done, and that the court's actions are not intended to have a chilling effect on the open and transparent courts or on responsible news gathering, and that the court is fully committed to the presumption of open proceedings under the applicable rules. That being stated, and as the court was listening, Mr. Burt has suggested that one of the potential sanctions is that for the camera for the remainder of the hearing, and not to show Mr. Robinson at all as a sanction for the remainder of today's hearing. And so the court considered that as well. This court does not wish to make a disproportionate decision on the actions, and it does note and does not minimize the violation. Therefore, this court will take up the suggestion by Mr. Burt that during the remainder of this hearing, that the camera shall not photograph Mr. Robinson at all, and that will be the sanction of this court. I will allow the pool camera operator to reposition the camera to adhere to that. Well, first, sir, I'm going to ask you to come forward because I want to make sure that's even a possibility. And again, I don't mean to put you on the spot. I'm simply, I don't want to set anyone up for failure. I don't want to make an order, and if it's not possible, then further sanctions could apply. And I recognize that it wasn't your anticipation to be on your own camera. But as it relates to not showing shots of Mr. Robinson for the remainder of this hearing, what are your thoughts?
I can do that. From where I'm positioned now, I can shoot this lectern, I can shoot the bench, and I can avoid the attorney tables altogether if that is what is desired.
All right. Do you need to do any repositioning of the camera to accomplish that? And I'm willing to give you that time to accommodate that. I just, again, I don't want to set you up for failure given what's happened. And so what are your thoughts?
No, I think the position I'm in, I am okay to avoid the attorney tables at this point and just shoot, this forward part of the courtroom.
All right. Thank you.
Thank you, sir.
All right. Turning to the parties, any clarification needed about the order of this court and the sanction that is imposed?
Your Honor, I only have one. It sounds like this issue is specific to video coverage and that the order not to take any imagery of Mr. Robinson would not apply, for example, to the still photographers. Do I have that correct?
Well, I'll hear from the parties before I offer that clarification. Do you wish to weigh in on that issue?
Just to indicate to the court that one of the problems is not just with the audio, with the video coverage, but most of the coverage is not covering the proceedings so much as close-ups of Mr. Robinson and comments about his demeanor. So if they catch him in a moment speaking civilly to his attorneys and he happens to smile, that then is twisted into evidence that he's some sort of a remorseless killer. So that applies to the still photography as much as what's going on with the video. So we'd ask the court not to permit still photography, at least for purposes of today. And I think after the court sees the motion, we'd be in a position to talk about the future. But I think for now, that's our request.
Thank you, Mr. Burt.
Thank you.
To the state.
Nothing further, Your Honor.
And any other inputs? All right. This court narrowly tailors its decision as to the violation, and the violation comes from the camera, the pool camera providing live feed. It doesn't come from the photographer. The photographer is the still, I don't know what the exact term is in this moment, it is eluding me, but the person who is operating the camera to take still shots is under the same requirements for this decorum order. I am not going to sanction them because what was before me with the 9-second clip and the 5-second clip doesn't apply to them. And so I'm going to limit the sanction as it relates to the pool camera photographer, again recognizing that the standing decorum order applies equally to the still camera photographer. Thank you, counsel. I appreciate you bringing this to the court's attention and the seriousness and professionalism that you presented this to the court. So thank you to all parties. And again, to the camera operator, do you need time to test out to ensure that there is any inadvertent capturing? I'm willing to do that. I just want to make it clear as day that Mr. Robinson is not to be captured in a sweeping shot in any form for the remainder of this hearing. All right. All right, counsel. With that in mind, how would you like to proceed?
Where is he? Oh. We'd ask the court to, and the clerk to swear in Mr. Gray.
Mr. Gray, if you would approach and stand before the court clerk to be sworn in.
You do solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. You can sit over there.
Mr. Gray, if you'd like, have a seat. Usually we have water bottles. If not, there's one right here. All right. And Mr. Gray, I'm sure you've heard this before, but if you could position the microphones close to you, just to ensure that the record picks up your testimony today. Thank you. Mr. Novak.
May I proceed?
Yes.
Thank you. Mr. Gray, how long have you been associated with the Utah County State Attorney's Office?
3 years.
Okay, and was it 3 years ago that you were elected to be the chief prosecutor of that office?
Yes.
All right. And had you ever previously been associated with the Utah County Prosecutor's Office in any other capacity?
I've defended on criminal appeals. I was a criminal appeals attorney for the state of Utah for 23 years, so I represented the state of Utah on those criminal appeals, which would include Utah County.
Okay. And did you ever have any professional relationship with the Utah County Attorney's Office in any other capacity other than the appellate work you did before you were elected?
Not to my recollection, no.
Okay. Because we're in an open session and based on some of the guidance from the court, I'm going to ask you questions. Well, let me back up. How many prosecutors are in your office right now?
Well, that are with our courts, they're actively engaged in our court system is 30, and then we have screening prosecutors as well, and that would be another 7 or 8.
Okay, so I'm going to try to...
I should stop because I also, my executive team, they don't have courts, so there's another 5 of them as well.
Okay, so let me ask a better question. How many prosecutors in your office represent the state in felony matters?
Well, all of them that I just described.
30?
I mean, even the screeners. Yes, the screeners, my executive team, they are assigned to special cases. Usually my executive team, for example, aggravated murder cases, some homicide cases. So they also are prosecuting and represent the state in trials.
Can you explain what you mean by the executive team?
The executive team would include Obviously, myself, I have two chief deputies, one chief deputy, another chief deputy's general counsel, and then I have a division chief over major crimes and a division chief over general crimes.
So is it fair to say that there are at least 24 prosecutors in your office who have substantial experience prosecuting serious offenses?
24? I don't know that I'd go as far as 24.
Okay.
Certainly all my SVU attorneys have that experience. Most of my violent felony attorneys have that experience too, but not all.
Okay. And do you know how many attorneys in your office have actually participated in homicide litigation?
I don't know the exact number, but I would say maybe 15.
Okay.
But I guess I should clarify, not all of them have the experience in aggravated murder cases, and that's why we specially assign those attorneys.
Understood. And how many do you believe have experience in aggravated homicide cases?
Probably 7 or 8.
And are all 7 or 8 assigned to this case?
No.
Are the 5 other than you who are assigned to this case experienced in aggravated felony cases?
4, well, either 3 or 4.
Of the 5?
Yeah.
Okay. All right, now I'm going to ask you some questions about a specific member of your office. And because the court may or may not ultimately order that attorney's identity remain sealed, you know what I mean by the word sealed, right?
Yes.
I'm going to refer to that person as Prosecutor A, okay? You all right with that?
Sure.
Okay. So how long have you known Prosecutor A?
About 3 years.
In your work as appellate counsel for the state, did you have any contact with Prosecutor A?
I may have. I don't recall. We generally send something out to, when we get an appeal, we generally send, the AG's office, we send something out to the prosecutor, ask them to fill out anything that we should know. More often than not, they never send us anything. And because it's an appeal, I mean, we're bound by the record. So there's not usually an occasion, but sometimes there is. But I couldn't say for sure that I've never talked. I certainly don't remember ever talking to him, though I could have.
Okay. Is Prosecutor A member of your executive team?
Yes.
Okay. And did you select Prosecutor A to be a member of your executive team?
Yes.
And that was at the beginning of your
Yes.
tenure as the Utah County Attorney?
Yes.
All right. And so you've had close working contact with Prosecutor A, who's a member of your executive team for the past 3 years?
Yes.
All right. And that, unless you're out of the office traveling or on vacation, that's basically every work day of the month, correct?
Yes.
All right. And have you met members of Prosecutor A's family? Ever? Let's just start with ever.
What's that?
Ever. Have you ever met members of Prosecutor A's family?
I have met his wife.
Okay.
I don't know if I've met his kids. I may have in passing, but I don't really. If I did, it was like at a function, they say, "This is my family," and introduce me. But I don't remember.
Have you socialized with Prosecutor A and his wife?
I think we went out to dinner once after a conference in St. George with some other prosecutors and their wives.
Okay. Have you ever been to Prosecutor A's home?
No.
Has Prosecutor A ever been to your home?
No.
You engage in recreational activities in any way with Prosecutor A?
No.
Whatever you do, running, pickleball?
No. I need to do more running, but unfortunately I don't.
All right, understood. Okay. Now, Prosecutor A has an adult child who was at the September 10th rally at Utah Valley University, correct?
That is what I mean, I don't have personal knowledge of that other than what they have told me. So like, I never saw that adult child, but I'm assuming, yes, that's true.
Okay, but on September 10th, 2025, at the moment that Mr. Kirk was shot and ultimately died from that shooting at Utah Valley University, you were in Davis County, right?
Yes, I indicated in the motion that it was Ogden, but it was actually Layton. So it was Layton.
Layton?
Yes.
Okay.
And I think that's Davis County.
All right, that's what I thought. And Prosecutor A was with you?
Yes.
Okay, and isn't it true that while you and Prosecutor A were in Davis County, you learned from Prosecutor A that one of his adult children was at the rally and was texting him about their experience?
Yes, I mean, we had just broken for lunch, and he showed me the text, Charlie Kirk got shot.
And that was a text that he showed you was from one of his children, right?
Yes.
And you knew at the time that it was a text from one of his children, right?
Yes.
What did he say to you? So I'm talking about Prosecutor A.
He said, look at what my child just showed me. And that's about it. And then he said, I should be getting down to UVU.
Okay, and then he left.
Yes.
And he, as far as you understand, he drove down to UVU.
Well, he drove towards UVU, yeah. He drove in the area.
Okay.
Ultimately, I met him, and then we drove together to UVU.
Okay, so you, according to the pleading that you authored the pleading that was filed.
Yes, I did.
Okay, so that, for the court's benefit, that's the state's opposition to the motion to disqualify. You
Yes.
authored that, correct?
Yes.
All right. And in it, you said that 10 to 15 minutes after Prosecutor A left the event that you were at in Davis County, you left.
Yes,
Did you also head in the direction of UVU?
Yes,
Okay, and then you and Prosecutor A met up somewhere?
yes.
And then traveled to UVU together in your vehicle or in Prosecutor A's? I guess there's a third alternative, which is you met somebody else and traveled with them.
No, I don't remember whose vehicle it was.
All right, did you talk to Prosecutor A?
It was my vehicle, I'm pretty sure.
Okay.
So,
And was that just about logistical convenience, like let's just go in one car, or was there
Yeah.
some specific reason?
yes, no, that was no other reason.
Okay. And on your way to that, what I'll call the meeting point, did you have any conversations by telephone with Prosecutor A?
Well, yeah, because we needed to meet. He left. I thought I would get some lunch first before I went to the command post. I got about halfway through that and said my mind was not on it. I needed to go to there. And so then we called. I believe I called him or he called. I'm not sure who called who, but then we met. We hadn't arranged that when he left.
Understood. But did he convey to you any more information about his child's experience in those conversations?
No,
Okay. And did you inquire, like, how's your kid or anything like that?
I did not.
Okay. And so you met up and then you went to the command post, which was established near the university, correct?
It was at the university.
Okay. Was it inside one of the buildings?
What's that?
It was inside one of the academic buildings.
Yes.
All right. And did you see Prosecutor A's child there when you were there?
No.
Were you introduced to that person?
No.
Okay. Did you have any conversations with Prosecutor A about whether they should stick around and wait?
No.
Did you?
My understanding, based on, my understanding was that everybody had left. We were told that most of the students had left. They had not, or attendees. So.
Okay, so as far as you know, Prosecutor A's adult child had left the university before you arrived?
As far as I know, my understanding was that, most of the students had fled. That first they went into buildings or whatever, and then they made their way out.
You are aware, I'm sorry, that's not a question. Give me a second, Your Honor, if you would. Okay, so did you spend time with Prosecutor A at the command post on September 10th at UVU?
Yes. We were going different places, but there would be times that we would meet up. But off and on is all I can say.
Okay. And did there come a time, either on the 10th or shortly thereafter, where he provided you with some information about how his adult child was doing, having been at this rally?
I don't remember him ever saying anything about that, and I never asked. I probably should have, but I don't remember any conversation regarding his child.
Was there anybody else at the rally who you are friends with, or is a relative of yours, or a close coworker that you're aware of?
I know that there were some people in my LDS ward whose children were there.
Okay. And when you say some people, could you be a little more specific? Like how many different families?
Just members of the ward.
Sure, but do you know how many different families that would be?
I think I was told about 2.
Okay. And who told you that?
One of the families.
Okay, so one of the families in your ward informed you that one of their own children had been there, and then another one had been there?
And then somebody else from the ward had been there.
I see. And do you know who those people are by name? I'm not asking you their names. I just want to know if you came to learn who they are.
Yeah, I came to learn who they are. Yeah.
Okay. And are you close with those people?
We're casual friends with one of them, but I don't think I learned that until well after we had filed the information.
Understood. When did you learn that?
Sometime after. I don't know.
So the information was filed obviously in mid-September.
Yeah, just in 6 days, so.
Right. Okay. And do you know, like, if you saw the children of the families in your ward who you understood were there, if you saw them on the street, would you recognize them?
I would recognize at least one of them.
Okay. Did you ever have any conversations with them or their parents about their experience?
I tried to stay away from that, other than they told me that the one was doing just fine and the other one was shook up.
Okay. And the other one was shook up. Is that the term used, or is that just your way to summarize?
That's my way of summarizing.
What did they tell you?
Having a hard time with it or something of that nature.
I'm sorry I interrupted you. So somebody told you, somebody who you know from your ward,
Yeah.
told you that their child, is their child a student at UVU?
Probably. They're young adults, so I'm assuming that. I really don't know for sure. Yeah.
And I think what you said is that they told you that their child was having a hard time with it.
What, that, not their child, but the other family's
The
child.
other family's child.
Yeah.
Okay, so it was like a secondhand thing.
Yeah.
Okay. And do you know if either of those young people who were at the rally, well, I'll put it this way, do you know where they were in terms of in what I'm going to refer to as the amphitheater area?
I have no clue.
The one who was having a hard time with it, did you share that information with the prosecution team?
I may have. I don't remember. I may have in passing.
Did you ever suggest to any of the law enforcement officers that that person be interviewed because they were impacted by what they experienced?
No. We don't interfere with the investigation. We try to assist. But law enforcement, they identify who they want to locate and who they need to interview, and I leave that to them.
Did the person giving you this information, so this is another adult in your ward, tell you more specifically about what their child and the other child actually saw and experienced?
No.
Okay, so you don't really know much more about where they were, what they saw. All you really know is one of them was having a hard time
Yeah.
with the experience that they had.
Yeah.
Okay. I understand you said that you don't interfere with law enforcement, but if you learn, even if it's somebody you know through your community, that somebody has suffered some emotional harm as a result of a criminal act that you are responsible for prosecuting, that's not information you would give to an investigator so that they could determine whether or not, so that they could go interview that person?
I didn't consider that as really relevant to the investigation, so no.
The fact that this young person was having a tough time with what they experienced is what you're saying isn't relevant? And when lawyers use the word relevant, we got to.
Well, it's relevant to them. As far relevant as to our case, I don't believe so, no.
Okay, understood. Now, there was a point in time in October, I think it was October 20th, where Prosecutor A sent Mr. Robinson's counsel an email disclosing that his adult child had been at the rally, providing us with some information.
Yes.
And so my first question is, were you part of a decision to disclose that information?
Yes.
Okay. And were you part of a decision as to how that information would be disclosed or how much information would be disclosed? Like what led to that email?
Well, there was no decision needed as to how much. The decision was to provide the information that we ultimately provided you. And that is not because we believed that there was a conflict of interest, but that was out of an abundance of caution.
I understand it's your position that you don't think that there's a conflict of interest. But I think that's clear. All right. Did the entire prosecution team, as it was constituted on October 20th, discuss this bundle of information that was being disclosed, or was it just you and Prosecutor A?
I know that me and Prosecutor A discussed it, and he may have discussed it with others. I don't believe anybody else was there.
When you discussed it?
When we discussed it, one of them may have been, or two, I don't know.
But the information that you obtained, sort of if I may, in the heat of the moment back on September 10th in Davis County, that Prosecutor A's child had this experience. and the text messages that went back and forth in the family, that information was shared with the prosecution team, correct? Everybody knew eventually.
Eventually.
Sure.
I mean, yeah, eventually.
Okay, so.
I mean, I only knew the fact that she was there. At the time, I only knew that she was there and that she left. That's all I knew.
Okay, but is it fair to say that you didn't set up any, but I'm going to use a term like firewall, to keep the rest of the prosecution team isolated from this information that one of their colleagues' children had this experience at UVU on September 10th?
No.
Is there a written policy in your office, either that existed when you arrived or that you've prepared since then, for how to evaluate whether one of your prosecutors needs to be screened off from a case?
You know, I'm not sure. I mean, we have those conflicts that come. I mean, the biggest thing on screening for us is if there's a potential conflict where information that the defendant has, one of our prosecutors has, because that's why you screen cases, is to make sure that shared confidences aren't also disclosed to, shared confidences with the defendant aren't shared with the prosecutor.
But you could agree with me that there are other types of conflicts that can arise other than what we might call the, privileged communication.
There may be. I mean, I think there can be. I can't think of any right now, but I think the rules are pretty clear with respect to shared confidences. You can't, screening isn't the end all of of how you treat conflicts. I mean, generally speaking, we will just conflict out to another office if we feel like we need to. One example, well, I won't go into that, but I mean, we've been threatened before, and there was an investigation, and of course, we conflicted it to a different prosecutor's office, because in that case, we were potential targets of this individual.
Understood. Okay, so you're not sure if there's a written screening protocol, but what you're saying is when we know it when we see it.
Well,
sort of what I'm hearing you say.
Sometimes we do. Sometimes I've had attorneys that felt like they couldn't talk after they've been conflicted out to at least know the victim, but notify the victim that that we were going to switch the prosecution. But there may be, I just honestly don't know. We keep an eye on those things and rely on our attorneys to notify us when there is a conflict.
But you knew as of September 10th that Prosecutor A's daughter attended the rally, correct? Was in the crowd, correct?
Yes.
Heard a shot fired, correct?
That, at that moment, I don't know that I knew that.
Okay, but you know it as of today.
Sure, I know it now.
You read their affidavit.
Sure.
Which says that.
Well, I knew it. I knew it once all of that information was disclosed to me.
Okay. And that they had to, with many, many, many hundreds of other people, run for cover and get out of the open space where they were, correct?
Yeah, I don't know that they had to, but that's what they did.
Well, you've seen the video you've probably seen many videos of that day, right?
Yes.
And weren't there law enforcement officers
Yes.
basically directing everybody to leave the open space so that they could
I don't
secure
know
it?
that I remember seeing those videos of the students or attendees leaving. I mean, I know that they left. I know that they ran away. What we learned later is that the shooter left immediately after the shot. So,
Right, but at the time of a shooting, you don't know
Sure.
how many shooters there
Absolutely.
are, if there's going to be
Absolutely.
follow-up,
Right.
if there are explosive devices, like all those things, right?
sure.
Okay, so let me ask you these questions about, well, instead of giving you a headline, I'll just ask the question. Once you had all of the information about Prosecutor A's child's experience, okay? What they saw, what they heard, what happened to them, the fact that they were separated from their personal property, all those things, okay? What I'm hearing you say is you never really discussed that with Prosecutor A and his family.
No. I mean, I did discuss, I don't know if it was day 2 or day 3. Law enforcement was there on the day of the shooting, the next day, and I think into Thursday or Friday. I don't remember exactly which day. And at some point, I was told that Prosecutor A's child left the bag there.
Okay. But if you never really talked about it with Prosecutor A, about the impact on his child and the family.
I didn't say that. Not on the day of, or, I mean, in the intervening time, he reported a couple of times that he talked to his child and said that she was doing fine. She reported to him that she was not having any issues.
Did you ever ask him, well, what about you? I mean, your kid was at this.
I didn't. Not that I recall.
Did you ever consult with anybody in the Attorney General's office concerning whether Prosecutor A's child's experience raised a potential conflict of interest for your office?
No, that's what I did for 23 years with prosecutors, is consult on that. And so I didn't feel a need to go to those folks. I mean, I know how to try to figure that out.
So when one of your responsibilities in the Attorney General's office was to consult about ethical issues?
Different matters.
Different
matters. It could be a variety of things.
Okay.
And I mean, if you're talking about ethical issues in particular, I don't know that the Criminal Appeals Division was the right folks to consult, but I'm not even sure of who from the Attorney General's office would. So.
Okay, but you worked in the Attorney General's office for a couple decades, right?
Yeah.
And what you're saying is that in your role as an appellate lawyer for the state, you would talk to prosecutors, I guess it's somewhat more informally, about ethical issues.
Yeah, every once in a while, yeah.
Sure. And so my question is whether you reached out to anybody in the Attorney General's office about this particular issue.
No.
Okay. Did you, and when I say you, I really mean you or anybody in your office on your behalf. Okay? Because you're the chief prosecutor, right?
Yeah.
So when I say you,
Yes.
I mean you and
Okay.
and people who work for you. What about the Utah State Bar?
No.
I mean, they give ethics guidance to attorneys on all kinds of issues, right?
Yes.
Okay. But no
No.
reach out. Other county attorneys in Utah, in other words, your colleagues who are elected chief prosecutors in their counties, did you discuss this with any of them?
No.
Are you a member of organizations of what I'll call chief prosecutors?
I'm a member of the Utah County and District Attorneys Association,
Okay.
UCDAA. I'm actually the president of that organization. I'm a member of SWAP, which is the statewide association of public attorneys and prosecutors. I'm actually the president-elect of that organization. That's a lobbying organization.
Okay, and do these associations have any mechanism for providing ethical guidance to their members?
No. I mean, when we have questions, we may shoot out an email and ask about things.
Did you do that in this
No.
situation?
I consulted no one other than my team.
Okay. I'm going to ask you 3 more categories just to be clear.
Okay.
Did you reach out to any law professors who
No.
purport to be ethics experts?
No.
Did you speak with any judicial officers
No.
about it? Court reporter, get the question and the answer? Oh, there you are.
Well, I just said that I have talked to
understand.
no one other than my team, so.
Okay. Did you ever discuss with Prosecutor A whether his child should or should not be interviewed by law enforcement?
No.
Are you aware of any?
Maybe, I don't remember.
Okay, so that may be important. You want to take a minute to think about that?
What's that?
That may be important. Would you like to take a moment to think about it?
I don't remember. I don't think so, but I do not remember.
The brief that you filed on behalf of the state, I'm sorry, the opposition to the motion has a couple affidavits attached to it, right?
Yes.
Okay. And one of those is the affidavit of Cole Christensen.
Yes.
And which for the court's benefit in the record is addendum C to the opposition. Special Agent Christensen writes in his affidavit that you and he in mid-December, so that's after the motion to disqualify was filed,
Yes.
went to UVU and basically conducted some observations and measurements, right?
Yeah, he was investigating that part. I did go with him because it doesn't involve trial. It's never going to come out in trial. So I did go there and assisted him. But he also had another officer there so that anything that I did could be corroborated by that officer.
Okay, but isn't it fair to say that basically what happened there is you said generally, Mr. Robinson's defense counsel have filed this motion to disqualify. I want to have some measurements done because I want to figure out what risks there were to Prosecutor A's child based on where they were and where you believe the shooter was, right?
Yeah, we have very good evidence of where the shooter was.
Okay, so I want to...
And it was based on Prosecutor A's child indicated where the location that they were, I'll use they, and based on the evidence of where the shooter was. So we wanted to confirm that. Now they didn't know where, obviously where the shooter was, but we wanted to confirm based on, we knew where the shooter was, and so we wanted to confirm that that they weren't in the line of fire. And that was important because that's critical to the state's case, is whether or not someone's in the line of fire.
Okay, so there's a few things there I want to try to make sure I cover. And if, Your Honor, if there's any point in time where the court or its staff need a break, just tell me, because I can break whenever the court needs that.
We'll be taking a break shortly, but I appreciate that, and if any of the parties do need a break, please indicate it as well. I want to be respectful to all parties.
Thank you. So the first thing I want to address, Mr. Gray, is that you knew that the defense had filed this motion to disqualify based on the relationship between Prosecutor A and somebody who was at the rally.
Yes.
And had the experiences that the court has already heard about. And so you basically went out with a law enforcement officer and you did an investigation and took a number of measurements.
He did, yes.
Okay, but at your direction, right? Because you're the one who
I asked him to do that, yes.
Okay. You say in connection with that there are some uncontested issues in this case.
Yes.
That's a term you used in your brief, right?
I'm sure that you will tell me where they're not contested, but.
Well, every issue is contested, right? I mean, the
So
state
is it, okay, go ahead.
I'm not trying to have a argument because the court reporter doesn't like
I
when we
stopped,
speak over each
so
other.
I'm not.
And I'm bad at that too, and I have been for a very long time. But your measurements, as documented in Mr. Christensen's affidavit, Special Agent Christensen's affidavit, are of things that you say are uncontested, but I just want to make sure.
So can I clarify that? I never said that the measurements were not contested. I said what was not contested is the fact of the things that Child A could testify to. That's what I was referring to as what's not contested. Child A, as demonstrated in the affidavit, can testify that Child A was there, that her Child A's location, and what the crowd did, what she did, and then what she ran in. That's what's uncontested.
But aren't these also uncontested things contested issues which you seem to suggest to the court are uncontested, and that is that the shooter was on the roof?
No, I didn't say that was uncontested. I said what she could testify to is uncontested. And if there was something different than that, that's certainly what I meant. I understand that all those other things could be contested.
Okay. You've made yourself a witness to evidence that you've used to try to advocate to the court that there's no conflict of interest, right? I mean, you basically, even though you're representing the state, you went out and you participated in a what you hope is a systematic way to measure whether Prosecutor A's daughter was in a line of sight from the place where the state alleges the shooter was, right?
Sure.
Okay.
But as far as making myself a witness, I was careful to make sure that there was Cole Christensen and then an officer from UVU. If you look at the case law says that prosecutors can participate in these interviews and so forth. What we do is make sure that someone else is there so that we don't have to testify. And the defense can't force the prosecutor to testify under those circumstances. That's the case law.
And it won't surprise you that competent defense counsel have the same practice. We don't interview witnesses without investigators present.
Right. And this was no different than that.
Understood. Okay, I do want to address another aspect of this line of fire situation. Okay, so it's the state's theory of the case, if I may, that the shooter was on a rooftop, correct?
Yes.
Okay. And what's the name of the building that the state believes the shooter was on?
I don't recall.
Okay. And so these measurements that are in Special Agent Christensen's declaration, you're saying were designed to basically, if I may, I'm not trying to put words in your mouth, rule out whether the child of Prosecutor A is in some ways a victim of this incident?
Not as far as a victim. We already understood that, based on where the buildings were, that the child was not in that line of fire, but we wanted to provide the measurements for this motion.
So what is the significance of the measurement? What is the significance of whether the child of Prosecutor A was or was not in a physical position where they could have been shot? What is the significance of that?
The aggravator, as you know, is that we're alleging that when the shooter killed Charlie Kirk, that he placed others in grave risk of death.
And you've
so
now,
anybody within that zone, if you will, was placed in grave risk of death.
Okay, and so you've now gone out and you've done these measurements from the place where you believe the shooter was, and anybody who's positioning at the rally, there's no line of sight, you're basically excluding all of those people from being among those referenced by that aggravator.
That's our understanding. We'd have a very difficult time proving that others beyond that point were also in that line of danger. I mean, we could, I guess, we could make the argument, but that would be difficult to prove.
And so is it your position that because this adult child would not fall within the category of people to whom the aggravator applies, there's no other connection between those people and the prosecution?
Not the crime. I mean, again, depending on whether, again, I rely on law enforcement to provide us with whether they have something helpful or not. We were able to determine based on what child, the prosecutor's child, there was nothing useful. There was no need to provide anything. I mean, we make those determinations when they provide it to us all the time.
Did you work with Special Agent Christensen on his declaration?
On what? No.
On his declaration?
I didn't.
Did somebody else?
Yes.
Another one of the members of your prosecution team?
Yes. That's generally the practice.
Okay. Was it Prosecutor A?
No.
Okay. Now, we've also, I should say, you also filed with the court Addendum B to your opposition, which is the affidavit of the child of Prosecutor
Yes.
A, right? And this person is a young adult who is a student at the university, right, at UVU?
Yes.
Okay.
That's what I'm told.
Okay.
I have no reason
Did you
to doubt
speak
that.
with this adult child in connection with the preparation of their affidavit?
I did not.
Do you know who did?
I do.
Who was that?
It was Mr. McBride.
Okay. And do you know whether Mr. McBride consulted at all with Prosecutor A about that?
I couldn't answer that. I don't know.
Okay. Did you read the affidavit?
Of course, I wrote the opposition. I better read the affidavit.
Did you play any role in the shaping of the affidavit in any way?
No.
It was just given to you, here's the affidavit?
Well, I mean, we were aware of what the student, I'm going to call a student now.
It's fine.
We were aware with what the student had said as far as what the student was aware of. And so we obviously, as I started writing based on what my understanding of that was, and I'm sure that Mr. McBride covered those areas to make sure that we were accurate.
Are you saying that the affidavit followed from your briefing and your briefing was based on your?
No, that's not it. My briefing was based on what the information that the student provided. And so to that extent, I'm sure when Mr. McBride talked to the student, that he would cover those things.
Okay, so what I'm missing is, where did you get the information about what the student experienced if you had not seen the affidavit?
That was from the prosecutor that is the parent of that.
Okay, so Prosecutor A told you, this is what happened with my kid.
Right, I mean, I think that's pretty established.
All right,
Okay.
Mr. Novak, this
Yes,
might
sir.
be a good time to take a brief break.
Whatever works for the court.
And just, not meaning to pressure you, I'm just trying to anticipate how much more time for questions you have for Mr. Gray, just for housekeeping purposes.
It's 4:06 according to this monitor. Oh, that's not right, it's 5 o'clock. The monitor says it's 4:06. That must be some time zone that somebody else lives in. At least another 20 minutes.
All right. So we'll take a 10 to 15-minute break, and perhaps council can confer in regards to housekeeping how we wish to address the remainder of the witnesses, whether in a setting today or a different setting. I'm not saying which way, but if you wouldn't mind consulting, and we can discuss that briefly when the recess is over.
That's fine. Do you want to give us some guidance on what works for the court and its staff? Because, I didn't know it was 5 o'clock, but it is.
Right. Go ahead and discuss that, and I'll talk with staff as well. That it gives me time to speak with them, and then we can confer
Very well.
with that. All right.
Thank you.
Court will be in a brief recess for 10 to 15 minutes.